Please welcome Mr. Pablo.
Well, good morning, everyone. First of all, I would like to thank you for being here and thanks for the invitation. Is it working? Okay. Okay. Sí. Okay. I'm Pablo Fernández Carballo Calero from Home Rock Monegear. I work. I'm full professor of commercial law, and I work for this law firm in the last 2 years. We are a boutique firm that we are specializing in intellectual property in the broad sense, so trademark law, patent law, and copyright law, but also on advertising law and unfair commercial practices. I'm going to talk about the protection of artificial intelligence outputs. I have 20 minutes to talk about this. It's okay, no? No. It's okay, no? All right, okay. It's better like this. No, I have 20 minutes to talk about this problematic of artificial intelligence outputs. I would like to say that it doesn't. No. Okay. Sí. Sí. Okay. The Museum of Modern Art recently acquired for its permanent collection this work, Unsupervised Machine Hallucinations, a generative artwork created by Turkish artist Refik Anadol that use artificial intelligence to produce visual designs inspired by the museum archives. But a few years earlier, in 2016, the world was amazed by the presentation of the next Rembrandt, a portrait created by artificial intelligence, thanks to 18 months of training by art historians and science and engineers that was able to reproduce the stroke and the style of the Baroque master. It's fine, I can say, okay, it's fine. Okay, in the course of creating these two works, AI generated art captured the attention of the two most charismatic and relevant auction houses in this peculiar market. In fact, in 2018, Christie's sold Edmond de Bellamy, the first work created by artificial intelligence to be publicly auctioned for almost $500,000. And in 2019, Memories of Passerby by German artist Mario Klingemann was sold at Sotheby's in London, becoming the second artificial intelligence-generated work to be sold at public auction. Having contextualized the object, Having contextualized the object of analysis, it is important to stress from the beginning that the artificial intelligence art binomial does not end or even begin with these works. Indeed, Harold Cohen in 1973 started to work with this robotic arm to create paintings. Also, we have another examples like the painting Full by Simon Cotton or Paul by Patrick Tresset. And these are all examples of the human desire to involve machines in the creative process. If we look at the impact of artificial intelligence in the art, there is no doubt that these intelligence machines write, paint, compose music. But does this mean that their novels, paintings, and songs are copyrightable works? Who would be, in that case, the author and the owner of the rights? Well, in order to analyze these questions, it should be noted that the relationship between authors and the software used to bring their creations to life has not traditionally posed any problems. Indeed, until a recent past, it has been a matter of course to state that the software used by the author to conceive a given work is in most cases a mere tool, necessary to a greater or lesser extent, but in any case, a simple support in the creative process. The program would be then the equivalent of the paintbrush to the painter, the compass for the architect, or the camera to the photographer. It would therefore not occur to anyone to think that novels written using Microsoft belong in any way to Microsoft company, as it would not make sense to conclude that the creators of the paintbrush, the compass of the photographic camera, were the copyright holders of the works of Picasso, Foster, or Leibovitz. Because the user of the tool and not the inventor of the tool would deserve the status of author of the results of timing. And why? Because after all, tools, however sophisticated they may be, are just support elements that, under the control of the users, enable the latter to translate or execute the product of their creative mind into the physical world. But this initial approach has changed radically with the development of artificial intelligence systems, and particularly with the development of machine learning software, a branch of artificial intelligence that produce autonomous systems capable of learning on their own. As Professor Guadamuth states, a computer program developed for machine learning is based on an algorithm that allows it to learn from the data entered, evolve, and make decisions that can be directed or autonomous. When applied to artistic, music, literal works, machine learning algorithms learn from the information provided by the programmers, and from that data, they generate a new work and make independent decisions through the process to determine what the work look like. An important characteristic of this type of artificial intelligence is that although the programmers can define parameters, the work is actually generated by the computer program itself through a process similar to that of a human thought. In this scenario, artificial intelligence systems are more than tools through which users express their own ideas, because unlike ordinary tools, such systems are capable of creating content with minimal human intervention. And framing the debate, it is essential to distinguish between works produced autonomously by artificial intelligence systems, we call this artificial intelligence generated works, and works produced by AI systems in which a relevant human contribution is verified, artificial intelligence assisted works. Category 1 would include those works in which human participation is non-existent or in any case is irrelevant or insufficient to support the principle of human authorship. In contrast, a second category would be represented by works generated by artificial intelligence systems with intervention, participation, or relevant input of humans. In my opinion, in the current scenario and probably in the near future, artificial intelligence systems are not capable of generating words autonomously, if by that we mean producing words without human intervention, out of nothing. After all, as Ginsburg pointed out, today's machines are fundamentally set of processes designed by humans to accomplish a specific task. In this context, I believe that the expression artificial intelligence generated works should include not only works in which human intervention is non-existent, if this is possible today or in the future, but also those in which human intervention is irrelevant to support the principle of human authorship. That is, works which, although there is human intervention, is not sufficiently significant to merit copyright protection. And in this scenario, the following questions arise. Can artificial intelligence systems be qualified as an author? Well, intellectual property laws worldwide take different approaches in many issues, but it should be noted that in general terms, the vast majority of IP laws, including continental Europe, United States, and Australia, call for human creativity as a prerequisite for protection. And this conception is based on a traditionally established idea. Original works created by natural or physical persons are the object of copyright. This debate also, as it was said before, is in the field of patent law. In this context, the exclusive attribution of the status of author to natural persons would exclude machines, even if the results they produce might externally appear to be intellectual works. As such, even if an artificial intelligence system has autonomously created a protectable work, it could never be qualified as an author. This approach is confirmed in this famous case of the selfie taken by a black-crested macaque named Naruto in 2011. In this year, the British photographer David Slater traveled to Tanggoko Reserve in Indonesia to photograph the local wildlife. On the second day of a 3 retreat, he followed a group of 25 monkeys to a place where they had stopped. At that point, the photographer tried to take a very close shot of a monkey face using a wide-angle lens, but the monkeys became nervous and would not allow him to get too close. So he decided to put the camera on a tripod, and from then on, monkeys played with the camera and surprisingly took several selfies, one of which would later attract the attention of the entire planet. But the problem is that Wikimedia used this picture, and the photographer said, this is a violation of my copyright, and Wikimedia said no, because this picture is not your picture, the macaco made the picture, so he's in any case the copyright owner, no? Well, the courts and the United States Copyright Office deal with this case. It was very interesting from a copyright point of view. And they conclude that the photograph was not copyrightable because only works created by a human can be copyrighted under United States law, which excludes photographers and artwork created by animals or by machines without human intervention. Then we have the solution of countries as India, United Kingdom, or Hong Kong that protect computer-generated works. According to this legislation of these countries, when it is the machine that creates in circumstances where it is not possible to identify a human author, the status of author is assigned to the person who makes the necessary arrangement from the creation of the work. It seems, therefore, that these legislations provide cases for minimal or low-level human intervention rather than cases in which there is no human intervention at all. Because if the artificial intelligence system were to generate a work in an absolutely autonomous manner, I mean without human intervention at all, it would make no sense to attribute the status of author to the person who makes the arrangements for the creation of the work, since no person would have made such arrangements. In fact, some authors, some scholars said that this legislation was introduced to protect systems as our own, that I talked before in 1973. In my opinion, artificial intelligence systems that autonomously produce works of art do not need incentives to conduct their creations. It has ironically been pointed out that providing artificial intelligence systems with wires, electronic devices, internet connections, and materials should be enough. And users who engage in merely banal, passive, or mechanical activity in the creation of the works do not deserve them. It is a different matter if, without recognizing a right of disclosure, it is the market itself that incentives or rewards users for the dissemination of autonomously generated content. It is the programmers who need incentives to create and develop advances and autonomously artificial intelligence systems, but the programmers or the entities they work for already own the respective copyrights to the software, which they can exploit in the form of sales or revenues or licensing royalties. In other words, assuming the existence of machines capable of creating art in an autonomous way, what would be the point of granting them protection? That would lead us to the public domain for these works. So far, we have analyzed how in most legislations, works created autonomously by artificial intelligence systems are not protectable by copyright. But this approach could change radically in case of works generated by artificial intelligence machines in which human participation is essential. In fact, that works, indeed, the fact that works produced autonomously by artificial intelligence systems doesn't mean that in the cases that we have human intervention behind, these works can be protected by copyright. In these artificial and automated processes, we can look at natural persons as possible authors, and artificial intelligence systems are mere tools, however sophisticated there may be. Simply put, these artificial intelligence systems are not fully autonomous, and therefore they are not fully intelligent either. Then, I believe that it is possible to apply the rules of copyright law when artificial intelligence systems are still an instrument at the service of human beings to realize their creative capacity. Everything, as you can see, depends on the degree of human involvement in the process. This is not a new topic because already in 1884, the USA Supreme Court have to decide if an artwork created with a machine, in this case it was a camera, was protected or not by copyright. Because in this year, 1884, the Supreme Court has to deal with who made the picture, the camera or the person who was behind the picture. And if you see, this is the same problem that it came with the computers in 1960. The commission in USA has to deal with this problem. Who creates the work? The computer or the person who is behind the computer? And for example, in this case, the US Supreme Court gave copyright protection to the photographer. And it's important to stress that the photographer was not the person who pressed the button. It was the person who creates all of the situation. This is a famous photograph of Oscar Wilde made by Napoleon Saroni. I tell you this because in the case of the monkey, as you can see, the monkey pressed the button of the camera, but the photographer could defend that he was the one that leads the monkey to press the button. So in this case, he would be the copyright owner. But this argument was not bought by the court in USA. So in view of the above, the key question is to determine what is the line that marks a relevant human intervention, or in other words, what is the line that allows a human being who has generated a work with the participation of an artificial intelligence system to be qualified as an author. In the United States, the USA Copyright Office has so far rejected applications filed by humans who, in one way or another, interacted with generative artificial intelligence systems to create the corresponding works. We have this first case, a recent entrance to paradise. This all came by the Davos project, that is the project that is behind all of these patent applications all over the world. Obviously, they have a lot of money to do all of these applications, but as it was said in the previous roundtable, most of them has been dismissed. But he also tried in the field of copyright law. Then we have this case, Area of the Down. This is a very, very interesting case because first, the USA Copyright Office grant protection, but then the artist, Cristina Castanova, said in her Instagram that the images were created with an artificial intelligence system. So the USA Copyright Office retired the protection for the image, not for the lyrics of the comic. And then we have another, this is a pending application of the same artist. Then we have this one, Theater de Opera Spatial. This is interesting because the one that applied for copyright protection shows that he gave more than 600 prompts to the machine to do the work. So he tried to demonstrate that he closed the path of the machine to do the work, no? And that the artificial intelligence machine was just a tool. But again, the USA Copyright Office denied protection. And then we have this one, Surrealist, that also shows how the USA Copyright Office is not right now very kind to conceive or to give protection for these works. But under Chinese copyright law, we have several cases in Beijing film law firm. The Beijing Internet Court found that the final article published by the plaintiff was copyrightable because was substantially different from the initial auto-generated report and reflected the author's personal judgment. Also, in another case, the court, in this case of Shenzhen, ruled that the subject article produced or assisted by an artificial intelligence writing software reflected the writer or editor's personal judgment. And we have a very interesting case, Li versus Liu, China first case concerning the copyrightability of artificial intelligence generated pictures. And here the Beijing Internet Court ruled that since the plaintiff had input over 150 prompts and experimented various parameters multiple times, in this case using stable diffusion, to generate the artificial intelligence picture, the plaintiff has exercised aesthetic choices and personal judgment in the entire generation process. Then the court concluded that the artificial intelligence generated picture here was a copyrightable work. This decision seems to contradict the USA decisions on the copyrightability of artificial intelligence outputs. Look that in the Theater of Opera Spatial, we have more than 600 prompts, and here we have 150. But for me, and I'm in my last 2 minutes, it is worth noting that the different outcomes made by the two courts are not because the Chinese courts believe that non-humans could be authors, or that Chinese copyright law does not require human authorship. No. The matter is that both jurisdictions seem to have different standards and interpretations about what constitutes human authorship. But China gave copyright protection because it was a human intervention, a relevant human intervention behind the work. We have this example of the next Rembrandt that in the academics field is the perfect example of a work made using an artificial intelligence system that could be protectable by copyright. In fact, the academics think that this is a perfect example of joint work because, as I said, arts experts, also science, and also experts in history of art show a machine to be the next Rembrandt during 18 months, but they didn't give the machine a lot of unstructured data. No, they gave a lot of data, but very specific from paintings of Rembrandt. there were more than 370 paintings of Rembrandt and more than almost 400,000 fragments of its paintings. And just to conclude, we have this also interesting case. It was the first Czech case on copyright and artificial intelligence. The Prague Municipal Court refused to recognize copyright protection for an artificial intelligence-generated image. The claimant had created this image using a leading text, and the prompt was, create a visual representation of two parties signing a business contract in a formal setting. For example, in a commercial room or in a law firm office in Prague. Show only the hands. And the generated image was sent by the claimant to the defendant, a Prague law firm, who then used the image on its website without obtaining consent from the claimant. The claimant then brought proceedings before the court, but the court confirmed that this was not a protectable artwork. Why? Because it was not the result of the creative activity of a natural person, and the court concluded that the image was not a protected work. As you can see, the prompt was so simple that everyone could do this. Just to conclude, I would like to say that in the European Artificial Intelligence Act, there are no specific provisions regarding the outputs, apart from the obligation of disclosure, the artificial intelligence-generated content. In Spain, we haven't had court cases by the moment, but the Spanish Intellectual Property Office has followed the criteria of the USA Copyright Office. And we have to say that in the self-regulation area, several bookstores have withdrawn a book belonging to the editorial Planeta for creating its cover with an artificial intelligence system. As you can see, the issue is still going on. So thanks a lot.
Much. So do we have any questions from the audience?
Hi, thank you very much, Pablo, for this presentation. Regarding the last case you mentioned here, the handshake.
This one?
Yes. Do you think the court could have relied on the absence, the lack of originality, not only the lack of human creation? The threshold of originality here is obviously lacking. I mean, it's just a handshake and it's a very banal picture. Instead of saying that it's not really a proper human creation eligible for protection, perhaps the court could have said the prompts are so simple and it's not really, there is no added creativity or added, the threshold, the bare minimum of originality is missing. Could that have been a ground for the same decision, the same outcome?
See, that's very, thanks for the question. This is very interesting. I didn't came inside the concept of originality because if you think in Europe, after Cofemel, no, it's that originality is that the author, that the artwork reflects the author's own thoughts, no, and personality. So this is different from another countries. In fact, in Europe, this is a really good question because it gives a lot of path to go to cases to try to defend that works are protected by copyright. For example, in German courts, we are dealing with this case of Birkenstock shoes, no? If they are not protected by copyright, because the concept of originality after Cofemel is that the work reflects author owns thoughts, no, and personality. Exactly. So, as I said, human nature is the prerequisite for protection, but you could go to the same conclusion if you say, no, this is not original, because with this prompt, so simple prompts, it doesn't reflect the author on personal choices. No? So that's a good point. I didn't do this difference because as you know, the concept of originality is not harmonized in European Union law. Then you have the Sweet and the Brown principle in the UK, you know. But the thing is that even you go for this human nature as a prerequisite for protection or originality, Because once you, it's a very good point, because once you have that there is human intervention, then you have to go, exactly, then you have to think that but for example, in the next Rembrandt, you can say, okay, there was a human intervention, 18 months, no, showing this system how to be the next Rembrandt. But then, once you pass this, for me, it's difficult to say no, but the work wasn't original. No, because, you know, it means that with all of this work behind, then you can say no, the work is not original. But if there is not a human intervention, you can go both. You can say no, there is no human intervention or there is no originality at all in this simple prompt, no? That two people shaking hands in a law firm. Thank you.
Any more questions from audience? No questions? Thank you so much, Pablo.
Okay, thanks to you.
Now it's time to honor you. So I would like to
Thank you.